Hi, I'm Gene Anthes, partner gbafirm.com and parole.com, and I want to take a quick minute to go over what to expect when you sit down with that initial consultation with a lawyer. When you come into my office, the very first thing that you'll do is fill out a client information sheet. Everything on there is confidential. There are strict rules about what lawyers can share, and we're not going to share anything with anybody else, but it's so that we generally have basic biographical information on you. When you come into my office, you may have a family member or someone else there for support, or maybe you brought some witnesses with you, and that's wonderful, and I want to talk to them too. But first, I want to talk to you by yourself without anybody else in the room. The reason is, one, I want you to be 100% comfortable with me telling me everything that happened. Two, we want to maintain that attorney-client confidentiality. If a third party is in the room while you and I are talking, in theory, the prosecutors could call that person on the stand to talk about what was said during that meeting. So don't be worried if I call just you in to talk about the facts of your case. Now, having said that, it's very important that you tell your lawyer everything. I want to know everything about your case, all the nitty-gritty details. I don't want to be surprised by anything. It's very important that you're 100% truthful with your lawyer so that he or she knows what to expect when he's defending you. Now, the other thing is, once we go over all the facts of your case, it can be helpful if we bring those witnesses in after the fact and then talk about what they saw or how they can contribute. What I tell people a lot of times is often the client will remember the details a lot more than the third party or the witness that they bring with them. And the reason for that is you're the client. You're the one that's charged with the crime. It sticks out in your mind. But that third party, to them, it's kind of an ancillary thing. So what I'll typically do is get that third party or that witness to write down what they saw so that sticks in their mind. Now, once you and I have gone over the facts of your case, which generally takes about 45 minutes to an hour, then we'll talk about procedurally what to expect. What's our plan of action? What steps should you be taking? Should your lawyer be taking? And what steps should you be taking as a client to give you the best chance of success? So as a lawyer, I'm going to go over what the different processes is in the court, whether we have to go to a grand jury, whether there's pretrial conferences, whether there's motion to suppress, or whether there's going to be a jury trial. As the client, I'm going to be telling you what steps you can take, whether you can do some counseling up front or perhaps maybe do some community service hours, again, to give you the best chance of success at getting your case resolved. Once the meeting is over, at that point, you decide whether you want to hire the lawyer, whether you want to get a second opinion. There's no pressure, but the big takeaway here that I want to stress is that it's important that you be 100% honest with your lawyer. That attorney-client confidentiality is the hallmark of our relationship. And if I can't know everything about your case, I'm not going to be able to effectively represent you. Now, do you have any questions about anything? You can reach out to gbafirm.com. We're always here if you need us, and we hope you never do.